Good afternoon.
Good afternoon. We ready to go?
Okay, Mr. Weiner is first.
Good afternoon, Judge.
Good afternoon, Mr. Weiner. Let's see, Leonard Williams, CR 2372. Set for docket call, I believe.
That's my understanding. We actually don't have the discovery in this case. I checked before I left just to make sure, and it's not on the portal for me. So I just need to request the discovery from the state and reset this case once I've had time to review it.
Remind me, Mr. Weiner, did you sub in for Mr. Williams?
I did.
When did that happen?
I believe it was October. Was it October or November? I subbed in for Mr. Stevens. So I can contact him directly if the court in the state would rather me contact him directly to try and get a hold of that discovery.
I'm just curious how we get from October to July, and neither the state nor the defense have talked about the case to provide discovery to the defendant.
He had an outstanding warrant for a period of time and was recently arrested. And so I think that's why the case kind of sidestepped for that period of time, Judge.
So you didn't seek discovery from the state when you subbed in?
We requested it in our standard letter of representation. But since he wasn't set, I hadn't gone back to check and see if I'd had the discovery, Judge. Yeah.
And state, when did Mr. Weiner saying that he's not received discovery? So once Mr. Weiner subbed in, the state didn't authorize him to view the online discovery?
Judge, I'm looking at it right now. We did still have Mr. Stevens listed as the attorney of record. So I'm not sure if I don't show that we ever received a letter of representation from Mr. Weiner. The last rep I have in the file is from Mr. Stevens, and discovery was still shared with him. I can switch that over to Mr. Weiner today, but that's what we internally showed, and that I think is the reason for this.
That'd be great. I did e-file a letter September 30th, but the DA's office has always been very good about sharing discovery. I don't think it's that big of an issue on our end, Judge.
I know, it's just concerning to the court that
Sure.
we're gonna have an unnecessary delay when we've had 7, 8, 9, 10 months to look at the discovery. So Mr. Williams would be able to announce what he wants to do today. This is Mr. Williams, 1, 2, 3, 4, 5. This is his 6th docket call since June of last year. And what I'm hearing is not ready because we've not reviewed discovery despite having been on the case since September and October of 21.
And that's correct, Judge. This is my first appearance, and honestly, while he was out with the outstanding warrant, I understand. I should have requested earlier, I guess, Judge. It's kind of out of sight, out of mind.
All right. Court will reset Mr. Williams for an additional docket call. This will be his final docket call, and we'll set that. Mr. Weiner, what did we set your morning case for? What date?
Look, and there is a August
23rd.
The 25th, Judge, is what I have on my calendar for Holly Mormon, I believe.
Yeah, that's an evidentiary day, though. That would be for the contested docket.
It was because it's a motion to proceed, rather, Judge.
Yeah. Are you available on August 23rd? Or, I mean, we could reset August 9th, 11th, or 23rd. I try not to put things on the contested docket so that we're only taking up contested issues on that 25th date.
No, I understand, Judge. The 23rd will be fine. As I mentioned, when we set Holly Mormon, I am specially set for a jury trial, but I have a client. My client's out on bond. And I believe there are some new cases on 392nd trial docket that will probably take precedence. So I would anticipate not going to trial. But if for some reason we are, I'll file a continuance and notify the state and the court as quickly as possible.
All right, court will reset Mr. Williams for a final docket call on August 23rd. And that'll be at 1:30, so long as Mr. Williams is in jail. If he makes bail, it will be at 9 a.m. in the courthouse.
Okay, thank you, Judge. That's all I have. May I be excused?
Yes, sir. Thank you, Mr. Weiner.
Thank you.
All right, Mr. Schmidt, are you ready?
Yes, sir. Skylar Tanner.
CR 2312, Mr. Tanner set for motion to revoke.
That's correct, Judge.
Go ahead.
Judge, you're negotiating with the state. I'd ask that Mr. Tanner be set on that August 9th date. If we can't resolve by then, which I anticipate we probably will, then we can take it up on the contested August docket. If the court would be so inclined.
All right, court will reset Mr. Tanner for motion to revoke hearing on August 9th, and we'll go ahead and we'll set it for August 25th for the contested docket if not resolved.
Thank you, Judge. I'll have Judge.
Thank you, Mr. Schmidt. Ms. Taberham, I do have Mr. Ashmore. He's in the Zoom waiting room. Also have Attorney Mark Trainer. So if any of their clients are available, we can bring them in.
I can get Shelton for Mr. Ashmore. Who's Mr. Trainer here to see, Judge? I don't have that on my docket.
Well, and Mr. Ashmore is also going to be standing in on all of Mr. Adams's clients. So Copeland.
Okay, so I can get those 5 in route right now, Judge. We're just waiting on them to show up.
And then Mr. Trainer is representing Corey Butler.
Yes, Judge, who our record shows in Department of Corrections.
Let me go ahead and bring in Mr. Trainer.
Mr. Cruz. Your Honor, we do have Mr. Cruz up here and Mr. Reed ready for if the 145 Spanish interpreter.
I know I do not have an interpreter yet, so we'll have to wait on that.
Okay. I'll get
Good.
to that.
Thank you. Good afternoon, Mr. Trainer.
Good afternoon.
All right, this is cause number CR 2262, State versus Corey James Butler. I'm going to note that he is in custody in the Federal Department of Corrections. Is that correct, State or Mr. Trainer?
That is my understanding. Yes, Your Honor.
That's the state's understanding, Your Honor.
So what's the state wanting to do with this case?
Judge, if we could get a reset for about 60 days, we can figure out what the federal prosecutors are going to do. We will at that time just determine whether we are going to move forward on these state possession charges.
Mr. Trainer, do you have your calendar available?
One more. Yes, Your Honor.
Will you look at September 20th or 22nd and see if you're available? 20th, 22nd, or 27th? See which one's better for you.
Problem about there. 2 seconds. I'm bringing it up. September 20th
20, 22, or 27?
to 27th is no good. 22, believe will be fine, 22. And then 20th. Yeah, either the 20th or the 22nd, Your Honor. Either one of those are fine. I'd probably prefer the 22nd.
Okay.
If I had a choice.
Okay, well, I will give you that choice. Court will set Mr. Butler for another status on September 22nd. That will be at 1:30. And if Mr. Butler is not in custody, that'll be at 9 a.m. in the morning. If he is still in custody, then Mr. Trainer, if you want to appear via Zoom, just notify my court coordinators and let them know, okay?
Okay, perfect, Your Honor. Thank you very much, and I appreciate it.
You're very welcome. Have a good day, sir.
All right, thank you. May I be excused?
Yes, sir.
All right, y'all have a good day.
You as well.
Hmm.
All right, so we're ready on Mr. Cruz.
Yes, Your Honor.
All right, Mr. Reed.
Mr. Reed, Judge is talking.
Excuse me, Judge. Yes, sir.
All right, we ready to proceed?
Absolutely.
All right, this is writ number WR 2256. And is this just a bail reduction?
Yes, sir.
All right, Napoleon Alberto Cruz. And Mr. Reed, are you wanting to call your client for the limited purposes of bail reduction?
Yes, sir.
Let me see if I have my, well, I thought I had our interpreter, Ms. Tabraham, but I'm not seeing our interpreter. I thought we had one in here, but it's actually Attorney Thomas. Sorry.
That's okay. We'll stay here.
Okay, I'll recall you. Just a
I
moment.
have Maria.
Okay, yeah, it's not here yet, so.
We'll wait.
Sorry about that, Mr. Reed.
Oh, that's okay, Judge. We're not going anywhere.
Do we have anyone else that's ready?
Mr. Hawkins is subbing in for Logan's lawyer this afternoon, and they like about 2 minutes.
Remind me,
It's a plea on Mr. Mays
oh, from the morning. Okay,
for safe P.
all right. And I also have Mr. Attorney Tom Massar
Okay,
for Isaiah Smith.
okay, now,
Oh, I see here.
yeah, he was in the Middleton unit.
Let me bring Mr. Massar in so he can hear what you have to say as well.
I told Mr. Massar in an email yesterday.
Good afternoon, Mr. Massar. Let's see, you're on mute there.
Perfect.
All right, good afternoon, sir. How are you?
I'm doing great.
Okay, this is cause number CR 2279, CR 2282, State versus Isaiah Everett Smith. We're set for arraignment today. It's my understanding that Mr. Smith is currently in the Texas Department of Criminal Justice in the Middleton unit. And he was apparently moved from the Middleton unit to a different unit. And there was not enough time for the court to have him bench warranted for today's proceeding. So court's going to have to reset for arraignment. If you have your docket, or if you have your calendar available.
I do.
Let's look at, are you available on August 23rd?
Yes, sir.
All right, we'll just reset arraignment for August 23rd, and hopefully that'll give us enough time to get Mr. Smith here so we can make some movement on his cases.
Yeah, yes. And Judge, I'll get with Tyler, see if we can get something worked out on this.
Hopefully we can work it out so we can plead him and send him right back.
Correct.
All right, thank you, Mr. Massar. We'll see you back on August 23rd.
At 1:30 again?
Yes, sir, 1:30.
Thank you.
You're welcome.
Bye.
Yeah, what do you think?
Yes.
All right, looks like I do have Miss Vieira's now. Do we want to try again? Let me bring her in.
Good afternoon, Judge.
Try it again. Give Miss Vieira's an opportunity to get logged in.
Good afternoon, Your Honor.
Good afternoon. How are you, ma'am?
I'm doing very well, Your Honor. Thank you.
Your Honor, I don't see our float. Here it is. Okay, so it says interpretation.
Patience, grasshopper, patience.
I know. You know, I don't have any.
Good afternoon, Judge Martin.
Good afternoon. Yes, ma'am.
Are you waiting on us?
Yes, are you?
It says we're in Spanish. It says our bandwidth is low.
Patty, you switched over to the Spanish channel?
Yes, sir. I think it's our.
I can hear you, yes, ma'am. Just make sure that Mr. Cruz, make sure that his inline microphone is
It's
not.
I think it's our internet. Hang on. I can hear it through here, so hang on. Can you hear? Can you see? Okay.
No, ma'am, it won't work because I won't be able to hear Mr. Reed because they'll have to switch. And there's gonna be an audio feedback loop with that laptop and my system. If it doesn't work, then we'll just have to do consecutive translation versus
We
simultaneous.
have over the ear. Okay, now try.
See,
All right, and Ms. Abraham, will you go ahead and turn on his video? You could turn on his video so that Ms. Vieras can see him because she may need to. And then have him step over, have him get right in front of that laptop. So it may assist her in seeing his lips as he's talking. There we go. Much better.
sí, sí, lo escucho, ¿no?
No, that's us.
Sí, lo escucho.
Can she not hear him?
He's got it.
Great, thank you. All right, Ms. Vieras, if you'll raise your right hand, I'm going to place you under oath. If you'll go ahead and state your name and your license number for the court.
Napoleón Cruz. Napoleón
Ma'am,
Alberto.
do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Frozen.
It's okay.
All right. All right. So we'll deal with the video issues as long as the audio is the more important one, because he does have the other video on him that appears to be working. So, all right, Mr. Reed, do you want to call your client for the limited purposes of the writ for bail reduction today?
Yes, sir, please.
All right, Mr. Cruz, if you'll just raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, Ms. Abraham, we're gonna take a recess in this hearing, let y'all try to figure out those connectivity issues, and I'm gonna take some of these others while y'all get that figured out. Sorry, Mr. Reed, maybe the third time will be a charm.
Okay, Judge Martin, it's okay. Thank
All
you.
right, Ms. Vieras, how much longer do I have you for until 2:15? Okay. No, I want to give Ms. Abraham an opportunity to try to work through some of the tech issues. So if you'll just bear with me for a few minutes, I don't think you'll. All right, thank you. All right, do we have any other inmates that we can go on while?
We got Mr. Hawkins's plea on Mr. Mays.
All right, let's go ahead and do that. And Patty, if the audio video is not going to work there, perhaps we can do some kind of call in to where we can just get the audio working, and then we can put him in front of the screen. I'm not sure.
Okay.
All right, let's see here, Mr. Mays. All right, this is cause number CR 2401, State versus Jason Lee Mays. And it looks like we are set to hear a plea on Mr. Mays for the third-degree felony offense of driving while intoxicated, third or more. Mr. Hawkins, can you go ahead and outline the plea for me?
Yes, Your Honor. It's going to be a guilty plea, Your Honor, with a 10 years TDC, probated for 5 years, with a condition of successful completion of the Safe P program.
Okay. 10 probated, 5 Safe P, court costs, fine, reimbursements, any restitution, any of that?
There's fines of $2,000, Your Honor. There's court cost of $290, and there's reimbursement fees of $840. And I believe I saw a judge as well, that there was and I don't know if it's calculated in the final amounts, but it shows a $750 court-appointed attorney reimbursement. And that's on the bottom of the judgment.
Okay. All right. Any other special conditions of community supervision other than Safe P?
Does have intensive supervision upon release from Safe P, Your Honor. And then after successful completion of that, I think after the 90 days, it goes down to I believe a weekly and then or bi-weekly and then a monthly. So that's the only other thing.
Okay.
I
Yeah,
recall.
and that is standard for our safe pleas. So, okay. All right. And he will be pleading guilty to the charge as indicted, DWI third or more.
That's correct, Your Honor.
All right, Mr. Mays, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may place your hand down. Just make sure you speak up loudly and clearly for me to the best of your ability, so I can hear you, and so my court reporter can take down what you have to say. Okay, sir?
Yes, sir.
All right, your name is Jason Lee Mays.
Yes, sir.
And Mr. Mays, are you a United States citizen?
Yes, sir.
Do you read, write, speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yeah, I'm bipolar. I'm diagnosed with bipolar.
Okay. Are you undergoing treatment for that or on medication for bipolar?
Medication for it. Yes, sir.
Okay. Do you feel like that medication that you're on today is enabling you to have a rational understanding about this proceeding that is going on against you today?
Yes, sir.
Okay. In this case, you are represented by your attorney. Actually, you're represented by Mr. Logan Sawyer, your attorney. Are you pleased with his representation of you?
Yes, sir.
Today, Mr. Matt Hawkins, another licensed attorney in the state of Texas, is standing in for Mr. Sawyer at Mr. Sawyer's request, I presume, to counsel you through this plea. Are you, or do you accept Mr. Hawkins standing in for Mr. Sawyer?
Yes, sir, I do.
Okay. And Mr. Mays, do you feel like you've had enough time to discuss this case with Mr. Sawyer and also enough time to discuss the paperwork and everything with Mr. Hawkins to the point that you understand what's going on in this case and you understand all of the paperwork that you signed and you understand all of your legal rights?
Yes, sir.
Okay. And Mr. Hawkins, do you believe Mr. Mays to be competent today?
I do, Your Honor. I went over all the plea paperwork with Mr. Mays, and he responded intelligently to all the questions I had for him. He did seem to understand, and so I don't have any questions as to his competency, Your Honor.
All right. Thank you, Mr. Hawkins. Appreciate that. All right, Mr. Mays, you are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more. A third-degree felony offense in the state of Texas does carry a range of punishment of not less than 2 years or more than 10 years, which is the maximum, and also a fine of not more than $10,000. In this case, I see the plea agreement, as Mr. Hawkins has stated to the court, is that if the court approves the plea agreement, your sentence would be assessed today at 10 years confinement in the Texas Department of Criminal Justice, which would be the maximum. However, the court would be suspending that sentence, placing you on community supervision. And as a condition of your community supervision, you would be ordered to attend the substance abuse felony punishment facility, also known as SAFE, in addition to your fines, court costs, reimbursement, fees. Is that your understanding of the plea agreement?
Yes, sir.
So your understanding of the plea agreement, I've explained to you the range of punishment. I find that the proposed plea agreement doesn't legally fit within the range of punishment. Understanding all of those things, do you still wish to go forward with your plea today?
Yes, sir.
All right, Mr. Mays, I'm going to ask you at this time, how do you plead to driving while intoxicated, third or more?
Guilty.
Mr. Mays, you're pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt. And Mr. Hawkins, any objection to the state's evidence in this case?
No objections, Your Honor.
The state's evidence contained in the stipulation of evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Ms. Heisel, can you give me the facts to support the plea?
Yes, Your Honor. Mr. Mays' wife called 911 and notified them that Mr. Mays was suicidal, that he had been drinking heavily, and he had also consumed a large amount of prescription medication and had left their residence in a vehicle headed into town, into Canton. Mr. Mays was located by Canton PD, who was able to execute a traffic stop. He was very disoriented. They were able to get him to the hospital. And based on records obtained from the hospital through grand jury subpoena, the state was able to obtain that Mr. Mays had a 0.19 BAC at the time that he arrived at the hospital shortly after driving in Van Zandt County. Additionally, Your Honor, Mr. Mays has previous convictions from 1995 and I believe 2016 for driving while intoxicated first and second respectively.
Thank you, Ms. Heisel. Mr. Hawkins, any objection to that summary of the evidence?
No, Your Honor, we covered that, and my client has reported those are true and correct.
All right, thank you, Mr. Hawkins. All right, then based on the evidence presented to the court finds that there is enough evidence to convict Mr. Mays of this offense. The court will follow the plea agreement in this case. Court hereby convicts Jason Lee Mays of driving while intoxicated third or more. Court will assess his sentence at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence today, place him on 5 years community supervision. Court will order him to attend the safety program as a condition of his community supervision. Court assesses a $2,000 fine, orders $290 in court cost, $840 in reimbursement. Mr. Mays, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. In just a moment, I'm gonna have you go over with the deputy to be fingerprinted. You can discuss the further steps with the probation officers that are there in the courtroom. And I know it's your understanding that you will go into custody today and you will await a bed to become available at that program. And once that's available, then you will be transported to begin your rehab. Okay?
Yes, sir.
All right. So, hey, Mr. Mays, I hope that you go down there and you work hard and that you listen to what they have to teach you, that you absorb it, that you learn it, and you come back and you apply it to your life. Okay?
Yes, sir.
All right. Thank you, sir. If you'll
Thank
step over the deputy to be fingerprinted. Thank you, Mr. Hawkins, for standing in for Mr. Sawyer and getting this done today.
Thank you, Judge.
All right. Well, I think we're ready again on Mr. Cruz. We're going to try the third time.
Thank you, sir.
Ms. Vieres, if you are available and ready, let's do a sound test for. And let's go ahead, Ms. Tibraham, let's go ahead and turn his video back on, just that way if it does work. Unless you think the video, do you think the video is causing the bandwidth on the connection to go down? If you think it is, then we'll just have Mr. Cruz move out away from behind the laptop so we can see him. Just have him move over.
You can hear, he can hear her now.
Okay, good.
You-
There you go. Okay, great. Thank you. I appreciate that, Maria. Okay, all right, Mr. Cruz, if you'll raise your right hand, I'm going to place you under oath. Mr. Cruz, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
See.
All right, you may place your hand. All right, thank you. All right, Mr. Reed, I've sworn your client in. If you'd like to proceed at this time, you may, sir.
Thank you very much. Would you please state for the record the full name, sir?
Can you repeat that, Mr. Reed?
Would you please state for the record your full name, sir? Mr. Cruz, how old are you? Since I can't hear the interpreter, are you hearing everything, Judge?
Yes.
That's right. I just want to make sure. Okay. And when you're not in jail, where do you live?
Vivo en Donnell y trabajo.
And how long have you lived there?
Mr. Reed, can you not hear
No, sir.
the interpreter?
No,
No.
sir.
Are y'all on the, are you in the English channel or Spanish channel in the jail, not on the laptop? You'll need to make sure you're in the English channel.
We're not in any. We weren't in any.
Okay, yeah, you have to be in the English channel.
Okay. Maybe proceed from where we
Yes.
are.
Yes, sir.
So how long have you lived at the address where you live right now?
Yes,
I still can't hear her, but I understand him.
Well, because she hasn't said anything yet. She's translating to him. Once he gives an answer, she'll
Okay.
translate it back to us in English. I believe that Mr. Reed asked Mr. Cruz, how long has he lived at the residence where he lives now? Is that correct, Mr. Reed?
That's correct, sir.
What? 8 años,
How long have you lived in Dallas County?
19 años.
All right. Are you married?
No,
You have children? I'm sorry, Judge.
sí,
How many children do you have?
2.
How old are they?
Yeah, you're gonna have to pause, Mr. Reed, and let Ms. Villiers do her job.
I know.
Yeah, I mean, we all know what see and no means, but in a moment, he's gonna say something that we don't understand.
It's not my first rodeo, as you know. Okay,
Una 17 y el niño 14.
all right. How long have we known each other? Me and you? How long have we known each other? Would you like me to repeat the question?
No, I believe she's translated it to him.
14 años.
That's correct. Sir, are you employed?
Sí,
Where are you employed?
en Dallas,
Doing what?
working in the construction. Trabajando en la construcción.
How long have you been doing that, sir?
10 años.
What is your income? How do you get paid?
1,200.
For what? Per day, per hour, or what? How much you get paid an hour?
Por semana.
How much per week?
800.
Very good. All right. How long have you been working for the construction company you're working for now?
8 años exactamente.
Okay. You have a place to go to right now, but if you get out of jail somehow, you have a place to live.
Sí,
Is it your place that you rent, buy, or what?
rent.
Okay, you rent from a family member, correct?
Yeah. Yeah. Mi tío.
Okay. And you have family members that live in Dallas, correct?
Sí,
How many?
seis.
All right. So if you can get out of here, you got a place to live, correct?
Sí,
You still have a job waiting for you,
sí,
and you have to come back here and go to court and finish these cases. You know that, right?
sí,
You're not going to leave the country or do anything except come back here and take care of your business, right?
sí.
Okay, do you have any bank accounts that have, how much money do you have in the bank, if any?
No tengo.
Do you have any savings accounts,
No,
certificates of deposits? You know what that is?
sí, sí, sir.
Okay, do you have any certificates of deposit?
No,
You don't have any outside funds, correct?
no.
Matter of fact, I am here pro bono. You know that, don't you?
Sí,
you have no manner of means of getting out of this jail with an $80,000 bond. do you?
No hay manera.
What is that noise?
It's an inmate.
It's an idiot.
It's an inmate.
That's what I said, an idiot. All right, Judge. You know that what this judge has to worry about is you leaving and not coming back, correct?
Sí.
You have any reason not to come back here and take care of your business?
No escuché bien.
Okay, let me just move on. He worries about society, you being out there in society. Is there anything to worry about with that?
No tiene. ¿Por qué?
And you have child support to pay, don't you?
Sí,
And you've always paid your child support, correct?
siempre.
Is that important? Is that important?
Sí,
Now, you've known me for 20 years, right? 20 years, right?
2019.
That's correct.
Exactamente 14 años tengo de conocerlo a él.
But I've known you for the last 20 years. Okay,
Oh.
we'll get to that later.
Él,
That is correct. Okay.
sí,
Judge, I think that's enough. He has, okay, go ahead. I'll pass it.
State, any questions, Mr. Cruz?
Briefly, Your Honor. Good afternoon, Mr. Cruz.
buenas tardes.
Mr. Cruz, when were you arrested on these charges?
Domingo 26 en la madrugada. El domingo del anterior de este que pasó.
So you've been in jail for 12 days by my count. Does that sound correct?
Correcto.
And you've been arrested on 3 charges. Does that sound correct?
Sí,
Possession of a controlled substance, penalty group 1, between 4 and 200 grams, a second degree felony. Does that sound correct?
sí,
And the bond is set at 50,000 on that one. Is that correct?
sí,
A possession of controlled substance, penalty group 1, between 1 and 4 grams, a third degree felony. That is a $20,000 bond. Does that sound correct?
sí,
And a unlawfully carrying of a weapon, a class A misdemeanor, which currently carries a $10,000 bond. Does that sound correct?
sí.
Judge, I have no further questions.
Is Mr. Cruz a citizen?
No, sir.
He's not?
He's not a citizen. He doesn't have an immigration hold, and I filed for asylum because he's from El Salvador. He goes back there and he knows he's gonna die anyway, so he's not going anywhere.
Okay, anything further, Mr. Reed?
No, sir, not this time, just target.
All right, and Mr. Clark?
He does not. He does not. Thank you.
Okay, Mr. Woodwhack, any evidence on behalf of the state?
No, Your Honor.
All right, Mr. Reed, argument?
Yes, sir. disappointed that we're even here to start with. Because this is not like Mr. Cruz. It's not like anything I've known with him for 20 years. I'm only here because I'm angry about it, and he knows it too. He's gonna take care of this business, because I'm gonna come up here and make sure it's taken care of. I just need the bond to be such that, so he can go back to work if he needs to. If some immigration issues come up, I'll bring it back to the court. I can assure you, with me knowing Mr. Cruz, and I'm the godfather to his 2 children, his oldest children, and have been for 20 years. So I don't know what happened to him. I'm not going to argue the case at this point, but I'm really disappointed. He knows that, but I think he'll do the right thing, and I'll see to it.
Thank you, Mr. Reed. Mr. Woodwhite.
Judge, Mr. Cruz has only been in for 12 days. State would ask that this bond reduction be denied.
Okay. All right, the court will review the evidence, and I will render a ruling at the end of my docket today, and I will provide a written order to council.
It's nice to
Thank
meet
you.
you.
All right, nice to meet you, Mr. Reed. Thanks, sir. Appreciate your patience while we got this worked out.
May I be excused?
Yes, sir, you may.
Thank you.
Let's see. I don't think so, but let me check with my boss, Ms. Tabraham, to make sure that.
Yes, Your Honor.
Do we need Ms. Vieira's?
No, Your Honor.
All right. No, ma'am, I think we're good. Yes, ma'am. It will be done in writing, and I will send a written order to both counsel for the state and counsel for the defendant. Yes, ma'am. Thank you very much. Appreciate your patience. Before you go, Maria, Patty, can you tell me what the issue was that you got resolved in case it comes up again in the future?
I believe that he had mashed the,
Inline?
yes, sir.
Yeah, that's what I was saying earlier. There's an inline mute button. We always got to check that. So, okay, great. All right. Glad we got that worked out. Now we know. All right. Thanks, Maria. You're welcome. Have a great day. All right, Deputy Phillips, are we ready on any Mr.
We're ready on Mr. Ashmore's client, and the others are here too, all but Vicky, Lavorne, and we do not have Stefan Mendez yet.
Okay. All right. Well, if Mr. Day doesn't show up, then we're not going to have Mr. Mendez. So I'm not sure. We may have to call him up and ask him. I'm assuming
We
that
have Mr. Manning here for Mr. Warner too. So
is Mr. Manning ready?
his client is not in the room at this time.
Okay, that's fine. That's fine. All right.
Your Honor, on Mr. Carl Days, I called his office and left a message that they needed to withdraw the warrant, the writ, if he was gonna not represent and I haven't heard back.
Okay.
That was early this morning.
Okay. All right, Mr. Ashmore, how are you, sir?
Judge, I'm doing great. Thank you. Thanks for allowing me to appear by Zoom.
You're welcome. All right, let's go ahead and bring Mr. Ashmore's client up, Mr. Shelton, Donnell Shelton, CR 2247 and 48.
Yes, sir.
Come on, sir.
All right, Mr. Shelton is set for pretrial today. Mr. Ashmore, go ahead. And you're on mute. I'm not sure if you're aware of that.
Thanks, Judge.
It's new technology.
It is. So we announced last hearing that we had filed a comprehensive pretrial motion, really seeking additional body cam videos that either were inadvertently not produced, were accounted for. Anyhow, long story, I've requested them again. The district attorney and I visited about them yesterday. I dropped off a 128 whatever thumb drive, which I think will be the easiest way to make sure that we have the entirety of the videos. So my request, Your Honor, is to reset this for, I think we'll need no further pretrial hearings once we have those body cam videos, the totality of them. Mr. Shelton and I have reviewed everything else that has been produced in this case, but there's 3 responding officers, the 3 closest to the incident, and those are the ones that are missing. Ms. Curry's office has kindly agreed to just reproduce everything on this thumb drive to make sure we have it all. And they're in process of doing that. I understand that one of the team members at the DA's office was injured, and so they're just a little behind on discovery, but they're working on it as quick as they can, Judge. So we're just asking for an additional reset to square that away, review that discovery, and be ready to make a final announcement.
State is going to be able to produce all the discovery for Mr. Shelton.
Yes, Your Honor. The only thing we were waiting on was discs from Mr. Ashmore, and like he said, he brought yesterday a large flash drive capable of holding everything. So Ms. Melton is working on that today.
All right, Mr. Ashmore, remind me, these are the dates that I have available: August 9th, 11th, and 23rd.
I'm checking now, Judge. Judge, there's some travel and some other conflicts in early August. Advanced family law CLEs 8 through 11. So if the court would indulge the 23rd, that'll give us ample time to collect the discovery, view it, review it with our client, and then be ready to make that final announcement.
Okay, court will set Mr. Shelton for docket call on August 23rd. If an issue arises after receiving the discovery that necessitates the filing of a pretrial motion, then the court will grant leave to file that, but we'll go ahead and set it for docket call today so that you can receive that and you and the state can go ahead and make your final offers and counter offers so we can get some kind of disposition, either a plea agreement or we'll set for trial.
Yes, Judge. Thank you very much.
You're welcome. Mr. Ashmore, Mr. Adams indicated to me that you would be standing in for him today on his case. Is that correct?
Yes, Judge.
Thank you, Mr. Shelton. You can go.
Yeah, Mr. Shelton.
All right. Is Rusty Copeland? Mr. Copeland, if you'll step up. So CR 22-6 and 7, State versus Rusty Wayne Copeland, set for pretrial. Go ahead, Mr.
Judge, Mr. Adams and I haven't had an opportunity to confer in detail, and I know that this is a second-degree felony. I don't know if there's an opportunity to ask for an additional pretrial, but Mr. Adams contacted our office late in the afternoon and just asked if I could assist. And you know, we did exchange the text and some email. So we're asking the court to just please give us a reset. So Mr. Adams can visit with his client more, because got 2 cases, both of them, one more serious than the other. I hope the state will not oppose that, just simply to not prejudice his client or Mr. Adams' good work.
And Mr. Ashmore, is your announcement going to be the same on all of Mr. Adams' cases?
Yes, Judge.
Let's see, Mr. Adams. Mr. Adams, I saw him coming up the stairs this morning, and he let me know before he left that you would be standing in. So I kind of inquired at that time whether or not it would be a substantive announcement, whether or not he had conveyed information to you so we could have a substantive announcement rather than just request for reset. He gave me the impression that he had communicated to your office what his announcement was going to be. So I'm concerned to the point where if that's the case, if it's just a request for reset, that's not what Mr. Adams had indicated to me. So I would rather not reset. I would rather wait for Mr. Adams. I know he told me he was going to be in Russ County this afternoon, but I'd rather wait till later this afternoon and get him zoomed in if just so his clients know what's going on in the case. But that's the impression that he.
Well, I do have some information, but again, all of those are requests. And I know you need to call them one at a time. Request reset for another docket call on Mr. Copeland, on Miss Vicky Lavorne. As I understand it, he's reached an agreement with the state for a reset because discovery is not available, not unlike Mr. Donnell Shelton's case. Roger Mccaslin, they have a plea offer, but Mr. Adams hasn't had a chance to discuss with his client yet. He's asking for a docket call setting. And Shannon Mcfarland, he has no pretrial motions or matters to raise and is asking the court to just set that forward for docket call.
Okay, well,
I wish I had more details than that, but they are.
Well, that's substantive in my mind.
Okay.
They're all set for pretrial, and you're indicating that he's indicating there's no pretrial issues and we can move forward. So that's a substantive announcement. Is that the announcement on Mr. Copeland or just reset for another pretrial?
Well, Mr. Copeland, Your Honor, is request for another docket call. And I'm not sure if there's a deal that's being considered or not. I don't have any further information on Mr. Copeland's case, except that given the gravity of it, the two charges, one worse than the other, I think he and Mr. Copeland, my understanding, just need time and are requesting another docket call. I don't know what the state's position is on that.
Okay. All right. Court will find that there are no contested pretrial issues for Mr. Copeland's cases. Court will set this for docket call on August 11th. That will be at 1:30. Yes, sir. Mr. Copeland, what is it?
Mr. Martin, I've been here 8 months and I've asked Mr. Adams for a bond reduction. He keeps telling me I'm a court-appointed client and I'm not eligible for a bond reduction. He says I'm not entitled to have a bond reduction since I'm a court-appointed client. He's told me that for 8 months. My mother's, she's had open heart surgery and got congestive heart failure. They've been diagnosed with congestive heart failure. And I have a job out there working for Duke's truck stop. And I could probably hire me a lawyer if I could just get on the streets. But he tells me I can't have a bond reduction because I'm a court-appointed client. I've never been told that before.
So, Mr. Copeland, let me ask you, are you wanting to file a complaint on Mr. Adams?
I would just like to be said if I could eligible for a bond reduction, sir. I mean, that's the only thing I've asked him to put in a motion for, and he tells me he can't do it.
Well, and Mr. Adams is not here to defend himself or your statements or clarify what he said or what he didn't say. So, yeah, it would be unfair for me to just take your word for what you're claiming that he's saying. So the best I can do for you, Mr. Copeland, is on August 11th, when Mr. Adams is here, we can bring that up again. And if he wants to file a motion to reduce bond, if not, then you're well within your rights. If you want to file a complaint on Mr. Adams, you need to get the form from the jail, fill out the paperwork, write in exactly what it is your complaint is, and then I will take that up on the 11th when Mr. Adams is here, and both of you are here, and I can hear from both of you.
Yes, sir, I understand. I was just trying to bring it to the court.
No, I understand. I appreciate what you're telling me, and I understand what your concern is, but I need to make sure that I get you and Mr. Adams, fair opportunity to address the court.
Yes, sir.
So on August 11th, I'll take that issue up with you and Mr. Adams.
Yes, sir. Thank you for hearing me.
You're welcome. Vicky Lavorne, CR 21266.
Yes. Yes, Your Honor.
All right, Ms. Lavorne is set for pretrial. Go ahead and make that same announcement so I can ensure that Ms. Lavorne heard that, Mr.
Yeah, yes, Judge. The state and the defense have agreed to reset this matter, not unlike Mr. Shelton's case that you heard on my case docket. Earlier, discovery is not available. It's the defense understanding the discovery will be available early next week. And so we're asking the court to reset that.
So Judge, if I could just correct the record, Mr. Ashmore is correct as to Mr. Adams's understanding as of yesterday. He and I had a follow-up conversation this morning. There were a couple of videos that were still outstanding and in question in Ms. Lavorne's case. However, the state produced those and Mr. Mr. Adams picked them up in early June. He then re-requested them. And basically we got on the same page this morning and realized that he had already picked those up. The state had already turned those over to him. So the discovery is complete in this matter, and we would ask that this be set for docket call.
Okay, court will set Ms. Lavorne for docket call on August 11th. And if Mr. Adams needs a pretrial hearing after receiving that discovery, the court will grant him permission to file late any pretrial requests. So Ms. Lavorne, we'll see you back on August 11th with Mr. Adams for your docket call. And that'll be the time that I'll expect to hear whether or not y'all have reached a plea agreement or you'll be requesting a trial.
Okay, thank you.
Roger Mccaslin, CR 21362. All right, Mr. Mccaslin set for docket call today. Mr. Ashmore.
Yes, Judge. The state has tendered a plea offer. The defense is requesting a reset for additional time to discuss with client. And I believe we're eligible for a first docket call. So we're asking the court to just move this to docket call. As I understand it, there are no contested pretrial motions filed, but asked to reserve the right to seek leave of court if something comes up later.
All right, so is Mr. Adams asking to have the case continue to another docket call so he can communicate the offer to the client or discuss it?
That's my understanding, yes. Needs additional time to discuss with the client, with Mr. Mccaslin.
All right, court will set Mr. Mccaslin then for a docket call on August 11th at 1:30.
What is the offer?
State, will you put the offer on the record, please?
Judge, it looks like we are offering 18 TDCJ on a change charge of tampering with a corpse.
18-year PDC
Yes, Judge.
on a reduced charge of tampering. And what level is that?
Tampering with a corpse is a second degree.
Any other questions, Mr. Mccaslin?
No, sir.
All right, we'll see you back on August 11th with Mr. Adams.
And just for Mr. Mccaslin's information, that offer was relayed yesterday. It has not been a long period of time since that's been given to Mr. Adams. It was just sent to him yesterday. I don't want to give Mr. Mccaslin the impression that we've given that to Mr. Adams a long time ago and he just hasn't done his job. That's not the case. It was just yesterday.
Thank you, Mr. Woodwine. I do appreciate that. All right, Shannon Mcfarland, CR 2235. All right, Mr. Mcfarland is set for pretrial. Mr. Ashmore.
Yes, Judge. Judge, the announcement the defense is making is that there are no contested pretrial matters, no contested pretrial motions at this time, and none anticipated at this time. We're requesting a setting for a docket call.
All right, there being no contested pretrial motions, court sets for docket call on August 11th at 1:30. Mr. Mcfarland, do you have any concerns or questions?
So this is, pardon me, this is the same concern that Mr. Copeland had as far as not having a bond reduction to where I could go back to work.
That's something that you'll have to take up with Mr. Adams.
Sort of been discussed. I understand.
Okay. Well, if you want to bring it up again on August 11th when he's back, then we'll all three discuss it. Okay.
Yes, sir.
But he'll need to follow the motion.
Yes, sir. This is just a rate. Thank you, Mr.
All right. Thank you, Mr. McFarland. All right. Thank you, Mr. Ashmore. I believe that concludes your cases and the cases that you stood in for Mr. Adams on. So I appreciate you being available and assisting the court.
No, Judge, thank you, and apologies for the confusion about the substantive issues, and thanks for being patient. So have a good one.
You can make it up to me later.
Yes, Judge.
Have a good day.
Thank y'all. Have a great day.
All right, Mr. Manning, are you ready?
Yes, Judge.
All right, state calls Taylor Warner, CR 22197. We're set for plea today. I'm sorry, we're set for arraignment today. Is that correct?
Yes, Judge. Mr. Warner's name is spelled correctly. He understands the charge against him. At this time, I plead not guilty and request to be set for pretrial.
All right, court will enter Mr. Warner's plea of not guilty into the record. We will set this matter for pretrial. And you wanted the August 11th date. Is that correct, Mr. Manning?
I believe so, Judge. Let me pull it up real quick. That's correct, Judge.
All right, court sets Mr. Warner for pretrial August 11th. Mr. Warner, if you make bond in this case, then your hearings will be held in the courthouse at 9 a.m. Okay, as long as you're in custody, then it'll be 1:30 and it'll be this way. Okay.
Okay, cool. Sounds good.
Mr. Manning, is that all you have today?
It is, Judge.
All right, thank you, sir. I appreciate you.
Thank you.
All right, with regards to writ WR 2242, State of Texas versus Esteban Mendez, court's going to find that Mr. Day did not appear in court to prosecute the writ, so the court is going to deny and dismiss writ number WR 2242. So if y'all want to send that communication back to Mr. Mendez, his attorney didn't appear, and that was the ruling of the court.
We're in the process of getting the extradition up here now, Judge.
Okay, do I have paperwork on an extradition? I don't think I do. No one told me about an extradition.
Well, Miss Wynette sent me a message and they had it back in the back of the jail area, book-in area.
All right, let me go get with her and see if she has the paperwork.
Yes, sir.
Judge, may the state be excused?
The state may be excused, Ms. Hazel. Thank you. Thank you, Mr. Woodward.
Thank you.
Thank you, Judge.
You're welcome.
Can you speak English? Thank you. Yeah.
Abraham, I'm gonna need this signed and dated, all that.
Our deputy has already completed that.
Do y'all have a copy there?
She was out here she was in here a minute ago and I had her, can you see that?
I can only see you on.
Right there, right here. So I can't see it.
You go up a little bit. Okay, perfect. Thank you.
Deputy McCaslin was in here for that.
Okay.
Is there anybody on here besides just you and I?
Yes, all of the world on YouTube. All of the world on YouTube and the Honorable Estelle Grisham. We are gonna. That's gonna conclude the business of the court with regards to the criminal docket. The worldwide